In the Karen Read case, it is snowing heavily, and I'm not talking about our New England weather. There's just been a blizzard of court filings recently, and oh, another plus in this episode, Michael Proctor has yet another profane text.
Seriously, another profane text? I'm leaning law.
And I'm attorney Andrew Myers.
Oh, can this guy keep his mouth quiet for like 5 seconds? He just has so much to say. He loves talking.
And this isn't a new profane text, really. It's a profane text that occurred towards the end of the last trial, or at the end of trial number 1, that we're just only finding out about now. There's a lot of stuff we're just finding out about now, even though it's been a number of months as we record this episode since the trial ended in a mistrial. And there's just so many emotions. I really don't know where to start. I guess what we'll do is start with a motion wherein the defense attorneys for Karen Read are still agonizingly trying to figure out what is going on with the video of the Lexus and why aren't they getting it? So we'll start with that one. This is the defendant's motion for a court order authorizing the defense access to the Lexus and Traverse and to the driveway at 1 Meadows Avenue in Canton to conduct independent testing and analysis. And actually, I said I was going to start with a different motion, but this is good enough. We're going to take a look at this motion here. Defendants Rules 14 and 17 motion for the court order. Can you see that okay, Lainey?
Beautiful.
Now comes defendant Karen Read and respectfully moves the honorable court pursuant to Mass Rule of Criminal Procedure 14A1A7 and Mass Rule of Criminal Procedure 17A2 to grant the defense access to the 2021 Lexus, as well as to the 2019 Chevy Traverse, the Chevy, for independent examination and testing by defense expert witness Robert A. O'Neill. Ms. Read requests that this court order that Mr. O'Neill be given brief access to the collision incident locus, that's the driveway at 1 Meadows Avenue in Canton, to collect necessary photographs, measurements, and scans of the area. Now, you might think I'm just reading this stuff, but this is going to blow your mind, I think. As grounds for this motion, Ms. Read states that these vehicles are currently and have been in the exclusive control of the Commonwealth. Justice requires that the defense have equitable access to these vehicles to create an independent scientific reconstruction of the collision. And they cite the rule. Further, Ms. Read requests that this court issue a court order and subpoena for additional daytime footage from the home security video. And it goes on. This is the part that's kind of hard to believe. Factual background. Ms. Read is accused of the following crimes, and we know all that. Our viewers know all this. The Commonwealth, via the Massachusetts State Police, conducted multiple rounds of vehicle testing, processing, analysis, and collision reconstruction without informing the defense of their plans to do so. On February 3rd, 2022, the Mass State Police were given access to the driveway at Meadows Avenue in order to complete forensic tests and photograph the scene. After the Commonwealth took possession of the vehicles, they conducted multiple further accident reconstructions and analyses, including as recently as July 24th, 2024.
Oh.
Yeah, that's after the first trial. The first trial was over July 1st of 2024. So after the trial, they're going back and saying, "Oh, hey guys, we gotta. Maybe we screwed up. Maybe we screwed up." But now this is the part that just makes me scratch my head. Inexplicably, the Massachusetts State Police conducted some of these tests in the presence of the decedent's brother, Paul O'Keefe, and his friend.
And not the defense.
And his friend Brendan Kane, both of whom are civilians. These tests were completed without alerting the defense and solely according to the Commonwealth and the state police's timelines.
I have a question.
Yeah, I have a lot of questions, but what's yours?
If I call them up, do you think they'll let me hang out too if I bring like a pack of beer or something? Like
I don't know. Are you one of Paul O'Keefe's friends?
I guess not. Yeah, you're right. I'm not in the friend squad. They'll be writing mean text messages about me. They're bullies. They don't like girls, I guess.
Now, do you remember earlier, sometime in the fall, they were extensively arguing whether, with respect to the telemetrics, whether the defense was going to be allowed to be present at and observe the Commonwealth's testing of the telemetrics, and they went back and forth, for quite a period of time. And the bottom line was, yeah, the defense could be there, but they couldn't stop it. They couldn't say anything. They could just observe. But now, if the shoe's on the other foot, if the Commonwealth decides that they want to take a look at the Lexus, Paul O'Keefe, come on over. Bring Unbelievable.
I'll be there, guys. I'll be
This is
there.
just absolutely unprofessional, unbelievable. Can't believe it happened. And when we started coverage of this case, I started out objective, as you'll remember. One of our commenters even said, "Don't you remember the first time you did these Karen Read episodes? You had a former broadcaster on who thought that she was guilty." Yeah, I remember that quite well. A good friend of mine, actually, who's no longer with us, unfortunately. But maintaining my objectivity all along, I've seen outrageous things like this. Give me a break. Nuh-uh. So this is all really basic stuff that a first-year law student would know. The defense has a constitutional and statutory right of access to the vehicles, the security camera footage, and the collision location. Ms. Reed requests access to the Lexus, the Chevrolet, the daytime security footage, and the collision location. The defense has a right to access and independently test this relevant and material physical evidence. And they cite a 2024 case which points out that the due process clauses of both the federal Constitution and the Massachusetts Declaration of Rights require that the Commonwealth disclose to the defendant material exculpatory evidence in its possession or control. Miss Reed's right of access to this evidence is just that. It's a right. It's not a matter of discretion. You know how we've had all these motions where, correctly, we've pointed out that some determinations are at the discretion of the court. Well, what they're saying here is this is a right. It has nothing to do with a discretion. So anyhow, federally, the right to independent access to evidence arises from the Due Process Clause of the United States Constitution. That is the Fifth Amendment. California versus Trombetta, that's a U.S. Supreme Court case going back to 1984, which describes the Supreme Court's development of the area of constitutionally guaranteed access to evidence as a safeguard to due process rights. So what this motion really is asking for, just let us go do some tests of our own. The Commonwealth's already, and my outrage was based on the fact that they allowed Paul O'Keefe and just his friend, who's his friend? Does his friend have any expertise? Does his friend, as you suggested, did he bring along a six-pack of beer?
Yeah. Well, I was gonna say that I thought about it a little bit more, and I don't think they would let me come even if I brought the beer, because I would see what they're doing and I'd ask them questions. I'm like, oh, what's that? Like, I'd be curious about it, and then they would realize that I'm actually know something about technology, and they'd freak out. So I guess I wouldn't be invited.
So in my view, having practiced law for 35 years in Massachusetts, that the judge has to allow this motion. How can a court allow the Commonwealth to do certain testing of its own behind everybody else's back and then not allow the defense attorneys the equal opportunity under due process in the Constitution to either conduct the same test or, observe the Commonwealth's own tests? So
You ask, how could they do that? I have an answer.
yeah, what's your
Easily.
yeah.
Easily.
Unfortunately, Laney Law, you're right. Unfortunately, that is correctamundo. It shouldn't be correctamundo, but it is. Further, in light of the state police's unexplained choice to have the decedent's brother and friend, both civilians, present during official forensic testing, Ms. Reed respectfully requests that any members of the Commonwealth's team, and especially the O'Keefe family, not be permitted within 200 feet of the vehicles, while the defense expert, Mr. O'Neill, conducts his testing analysis. Ms. Reed understands that it may not be possible to conduct a fully independent test because the vehicles are in the custody of the Commonwealth, but fairness requires that this analysis be kept private from those who might want to prematurely glean insight from our findings. So it's just, the rest of this, just it goes on. It talks about, discovery requirements. It talks about what you need to do to establish discovery violations. For the foregoing reasons, and in the interest of fairness, Ms. Reed respectfully requests this honorable court grant her motion in limine for access to the above-mentioned vehicles, the home security camera footage, and the locus of the collision incident. So that's the first motion we take a look at today. And I don't know, this is something that we really haven't addressed before. And speaking of things that we haven't addressed before, people way outside of this channel, we are what we are, but people way outside of this channel have noticed that Paul O'Keefe sits in that very small courtroom right within feet of Karen Read, staring at her. And people have mentioned that he's staring her down. And after trial 1.0, as Ms. Reed was leaving with her people, her attorneys and family, etc., a comment was made by Paul O'Keefe. I don't have the exact words. I think I'm very close in saying that after the trial, Paul O'Keefe said words to the effect of, "We're not done with you yet." So a person that has that, and I feel for someone who's lost their brother. I lost my brother at a very young age, so I have compassion for that. But you know what? To be making comments like that, to be staring down the defendant, and then to be present during the testing of a vehicle. I mean, I'm not the judge, but if I were the judge, I wouldn't even allow any of the Commonwealth's tests to go in. So anyhow, people tell me not to tell personal stories, so I'll stop. Let's see. The next motion that we have.
Stop! I'm gonna. It's ridiculous.
Okay, the next motion is defendant Karen Reed's motion to compel discovery. Aren't we done with discovery in this case yet?
Never.
Remember Sandra Birchmore?
And discovery happens in the middle of a case too, just a little,
little
here, a little there.
We're going to revisit Sandra Birchmore in a minute, but not until we get back to the Lexus video. Now comes the defendant, Karen Reed, who respectfully moves this honorable court pursuant to Mass R. Crim P 14A to order the Commonwealth to produce the following discovery. The items of discovery set forth herein are relevant and material and must be provided in accordance with Ms. Reed's constitutional rights to effective assistance of counsel and to due process under the law as guaranteed by Article 12 of the Massachusetts Declaration of Rights and the 5th, 6th, and 14th Amendments to the United States Constitution. Okay. All true. So what are they going? You say, okay, we've had, this case has been, ongoing now for 3 years. What more discovery could there be? Well, how about what really happened with the video at the Canton Police Department?
Just a crumb of video, please. A crumb of metadata.
Defense request number 1, request for all chain of custody logs, reports, evidence logs, and or other documentation regarding how the district attorney's office and or state police came into possession, I should say, of each distinct production of video surveillance footage from Canton Police Department, CPD, that has been provided to the defense. Per defense counsel's November 8th, 2024 email, Ms. Reed seeks discovery of all chain of custody logs, reports, evidence logs, and or other documentation regarding how the Norfolk County District Attorney's Office and or Massachusetts State Police came into the possession of each distinct production of the video surveillance footage from CPD, which has been turned over to the defense in discovery. Remember this whole issue? They brought in the backwards inverted video of the vehicle, and they've produced other snips and snails of the video, but the defense has never received the original digital video.
I think if you just keep giving them clips and you just keep going around it and you just keep saying that you're gonna give it to them, I think you can just kind of bypass the actually giving it to them part.
Do you get a paycheck from the Canton Police Department?
Sorry, I'm just trying to have beers with them and check out the car. I'm just curious to see how they do the analyst like analysis.
Yeah, this is beyond belief that it was even allowed to go in as a clip that was only brought in the middle of the trial. To me, that is surprising. It should never have happened. Again, trying to be objective. This information will provide defense counsel with relevant details about when, how, and from whom the Commonwealth obtained all of the CPD surveillance video footage, how it was logged into evidence, and what footage exactly the Commonwealth has in its possession and how that came to be. These details are relevant and necessary to contextualize the raw CPD surveillance video footage and to assess whether that video footage was subject to tampering. Attorney Brennan indicated via email on November 25th, 2024, that he would request these records, but no records responsive to this request have been produced to date. I seem to remember, and correct me if I'm wrong, the judge said she wanted that turned over in a week, didn't she?
I mean, sometimes my professors at college will give me a due date on a homework, and sometimes, I hand it in, and sometimes I just don't. It's just like, and
Yeah.
sometimes is the penalty like it's just like is one homework is not handing in one homework really gonna take you from an A to like a B or from a B to a C? Not usually. They're probably just like, yeah, I'll get to my homework. I'll get to it.
There's got to
I'll
be
I'll wait
something.
till I get graded.
There has got to be something very, very, very relevant and discoverable and exculpatory, and it's a Brady violation that this entire thing hasn't been turned over now today. Before the trial, which began on April 16th, back on April 15th, way back on 2024, it's just impermissible, improper, unbelievable that video was not produced before the first trial. The whole thing should have been thrown out, objectively speaking. The whole video should have been disallowed unless it had been provided before the first trial. So it's unbelievable that at this point, almost a year, 3 years after the crime, almost a year now since the first trial started, that they're still saying we need it, we don't have it. So the
Mhm.
only reasonable inference can be that if they produced it, the Commonwealth's case would be dead. Yeah, I said that. If the entire Canton Police Department videos, surveillance of the garage inside and out, because now we know from the revelation that Brian Higgins was there around 1:30 on January 29th of 2022. We now know that there are inside videos and outside videos. And the fact that they have not been produced to date is just outrageous.
But then also the fact that we did like we had a whole first trial, no video, and then like you just said, he had a week to produce them just now, and we're just still chilling on him. He's gonna see like if he needs the A or if like he's at a B and he wants to bump it up or if he's okay with where he's at, I think is what's going on. I don't know why the case isn't getting thrown away. This teacher really needs to kick this student out of the class, but
Absolutely.
but this is where we're at.
So I'm just thinking, it's possible that there are no logs. It's possible that, some putts just in the back room of the prosecutor's office in Canton or over at CPD. Some putts just, got the video, downloaded it into his laptop, did the editing, edited it up chops, and then deleted it. It's quite possible that we're talking about people that have shown that they're not overly professional. It's quite possible they chopped it up and just got rid of it. Like you or me, like I had a laptop burn out, and fortunately I had most of it backed up, but not everything. Not everything was backed up. So, I don't know if the best forensic IT person in the world could drag stuff. Remember that old laptop I had that used to it was
Oh
so
my
hot it would almost catch fire.
I like Andrew's perseverance though, because he really held on to that thing until it practically did explode. I was surprised it made it as far as it did.
It would get so, here we go talking personal stuff, and people write down we don't want you talking about personal stuff.
Criminal behavior.
This will be my last story, but it would get so hot that I would have to get one of those ice packs out of the freezer and put balance the laptop on top of that. So it would cool down, cool enough that I could touch it. But anyhow, that's the kind of, Keystone Cops stuff that I think is possible, and it's possible that they lost the logs. But all right.
Well, and I know you said that you're done with the personal stories, but just to give the haters more fuel, my personal story is that I almost sent you, I don't think I sent this to you, I almost sent you a screenshot of a post on Threads that was like, do you think it's okay to delete my English essay from 8th grade yet, or should I hold on to it like for a little
Yeah.
bit longer? It's
Yeah.
like, so it's just like I think about like us sending stuff back and forth, and like most things we can pull as quickly as easily as we need it, but this video,
Well, I don't have
know.
anything from 6th grade, but I still have a couple of papers I wrote in college. I have 9 credits of propaganda studies from the late great Professor Walter Littlefield, who was just one of the most brilliant guys I've ever met. And he taught propaganda. I have 2 papers. I have 2 papers that I wrote on propaganda. And even though I wrote them those many years ago, the stuff in those papers is more relevant today than it was then. But to go to something really, really, really serious, as if the Commonwealth's messing around with that vehicle isn't serious enough. Here's defense request number 2, an unredacted copy of Massachusetts State Police Report number 26. Defense counsel also requested via its November 8th, 2024 email to Attorney Brennan an unredacted copy of Mass State Police Report number 26 associated with the investigation into the death of Sandra Birchmore. Remember Sandra Birchmore?
Yeah.
It was produced in NOD number 47. The police report number 26 is relevant and must be provided in accordance with Ms. Reed's constitutional and statutory rights. The investigation into the death of Sandra Birchmore has involved many of the same material witnesses in Ms. Reed's case, including but not limited to Sergeant Michael Lank, Daniel Whitley, Trooper Mike Dunn, Trooper Zach Clark, Colleen Crawford, Detective Kevin Albert, Lieutenant John Fanning, Trooper Garino, Lieutenant Brian Tully, Deputy District Attorney Lynn Bayland, who's retired, and District Attorney Michael Morrissey. Recognize that cast of characters?
Yeah, unfortunately. I wish I didn't.
Given the similar allegations of misconduct by state actors in the Birchmore and Reed cases, the statements that material witnesses in the Ms. Reed's case make it in relation to the Birchmore investigation are relevant for impeachment and bear on the credibility of those witnesses in the instant matter. So, Sandra Birchmore, just a very quick nutshell for people that didn't follow the case. Sandra Birchmore was a young girl that at the age of 12 joined up the Stoughton Police Department Explorers Club. And by the time she was 15, she had been groomed, and at least 2 of the officers took advantage of her in a physical, inappropriate way. And jumping forward again, this is a nutshell, folks. We did several entire episodes on this. A number of years later, when she had been impregnated by one of the officers who had been abusing her, that officer ended her life. And the Canton Police Department did a Keystone Cops half-hearted investigation, and Michael Morrissey looked the other way, and they got away with it for years and years and years until the feds finally indicted Matthew for the death of a witness. That's how they got around the fact that, generally speaking, the federal government doesn't have jurisdiction over state crimes, including the big M. So that's how they got away with that. But that's just a nutshell. I know I've omitted a lot of details, but that's...
And we did go more in detail on it on our channel, so maybe we should link to that below.
Okay. All right.
I'll write a
We'll
note to do that.
All right. So, why is all of that relevant? Well, despite defense counsel's request, the Commonwealth has not yet provided the defense with Mass State Police Report number 26. In fact, Attorney Brennan replied on November 25th, 2024, that because the Sandra Birchmore case now involves a federal investigation. Yeah, you know why, Hank? Because the district attorney in Norfolk County did nothing. He drank lattes in his office rather than pursue the case. The Commonwealth has possession, custody, or control of relevant reports from the Birchmore investigation that include statements by material witnesses in the Karen Read matter. Many of those statements have since been undermined and discredited, and consequently, they bear on the credibility of those material witnesses and are directly relevant to Ms. Read's case. And I have to say they're at least relevant for the purpose of impeachment with respect to any, let's use the word methodology that the crime scene was investigated. I mean, in the Sandra Birchmore case, there were a lot of irregularities in the way that was investigated. And solo cups and Stop and Shop bags.
You don't do your investigations like that?
I'd never seen that before. No, I've seen crime scene investigations back when I was a reporter. I saw bunches of them, and no, I never saw solo cups.
Well, I guess my question needs to be because that's a great point, because this is something that happens all the time. Is this not just a kit that you're they're prepared with on board? Or if you're going to this scene, wouldn't they presumably have that kit on the way?
You would think so.
You would think so. I mean, we've had a lot of questions about this case. I keep asking a lot of questions that to me would seem like common sense, but that's the reminder that I guess common sense is just a concept, not a real thing.
Crazy. Then defense request number 3, an unredacted copy of the public record response relating to all email correspondence and communications associated with the Sandra Birchmore investigation. In that same November 8th email, defense counsel requested an unredacted copy of the public record response relating to all email correspondence and communications associated with the investigation into Sandra Birchmore, produced in NOD number 47. The Commonwealth has provided defense counsel with a copy of the response to a Public Records Act request concerning all mail correspondence and communications associated with the investigation into Sandra Birchmore. However, the copy that the Commonwealth produced is the same redacted version made available to members of the public. Critically, the interests of the public in obtaining and reviewing these communications is less substantial than that of the defense, and that's absolutely true. The redacted version of the report omits information that is relevant to Ms. Read's case and critical to her defense, and thus insufficient to satisfy the Commonwealth's obligation under Massachusetts liberal discovery rules. And then they cite some cases, which aren't that old, 73 and 80. As described above, Attorney Brennan indicated to the defense on November 25th of 2024 that if it wants these records, it should contact the U.S. Attorney's Office seeking redacted records. For the above-mentioned reasons, including the inadequacy of redacted records for defense purposes, the aforementioned relevance of these Birchmore records to Ms. Read's case, and the legal obligation of the Commonwealth to provide such information when it is within its possession, custody, or control, that response is insufficient to satisfy the Commonwealth's discovery obligations. No records responsive to this request have been produced. And so this goes on with some other similar requests. I think the last one that we'll look at is E. Defense request number 5, request for all communications, documents, reports, memoranda, recordings of interviews, physical evidence, findings, and or other evidence relating to the internal affairs investigation into Trooper Michael Proctor, including transcripts of the administrative proceedings. Now, this is Michael Proctor, who at the end of Read Trial 1.0 was suspended from his duties. Now there have been 2 days of hearings at the Mass State Police, and a third is scheduled in March. There was one in January, there was one in February, and another one is now scheduled in March to determine his future. I don't know what could be taking so long. I really don't.
Oh my God, I don't even. That's a good question. It goes back to my other questions, all the questions I have.
Yeah, it goes back, he said she has no ass. He said that she had a leaky balloon knot. And he said, if you could imagine, he said even worse things than that. I mean, I said before, after I got out of high school and before I went on to college, I spent a year and a half on a loading dock, loading and unloading tractor trailers and having the absolute fun of driving a forklift. And you can imagine the language that, we used. And I spent the rest of my life. Anybody that knows me knows it's a struggle for me to make it through a sentence without some sort of profanity. But if you're a professional in your professional life, I don't do that here. I don't do that in court, and I don't think any professional should go to even the worst truck driver. And I'm thinking of one right now who had a name for Massachusetts. Anyhow, I don't think even the most profane person in the world would speak the way that Proctor did and say some of the things that he said about somebody he's supposed to be objective about and objectively investigating. He's supposed to be investigating her on a professional level, and he's saying all this stuff. First of all, I don't know what it means that she had a Fall River accent. I mean, anyhow, how did I get so off track? Here's the final request. On November 8th, 2024, Defense Counsel requested the production of, inter alia, all communications, documents, reports, memoranda, recordings of interviews, physical evidence, findings, and or other evidence relating to the internal affairs investigation into Trooper Proctor. Attorney Brennan has provided Defense Counsel with a small number of generic letters about the internal affairs investigation, as well as an internal affairs report, which states simply that Trooper Proctor has been suspended. So this goes into a lot more detail. If a prosecutor, and this is a holding from the Massachusetts Supreme Judicial Court, saying if a prosecutor has possession or control of the records of an investigation by an internal affairs division of a police department with respect to a particular matter, the prosecutor must review that material in response to a Rule 14 motion for the production of exculpatory facts. And there's a 1998 case balancing the need to provide criminal defendants with avenues to access relevant information contained within internal affairs files against the reasons to shield internal affairs records from automatic disclosure. Accordingly, the Commonwealth has a discovery obligation to provide any communications and documents that relate to the internal affairs investigation of Trooper Proctor and that are in its possession, custody, or control. Those communications and documents are relevant, given Trooper Proctor's role as the lead investigator in Ms. Reed's case before his suspension. The Commonwealth has not met its obligation to produce this evidence, and thus the defense seeks to compel its production. And the defense team goes on to point out that a lot has been going on behind the scenes here, but the Commonwealth has not been forthcoming in producing everything. And, I think you'll remember back when Mr. Brennan, back in, I believe it was the early fall of 2024, he said, I'm going to get to the bottom of everything and I'm going to produce everything and I'm going to make sure that we have a better trial the second time. Those were not his exact words, I know. But I mean, so things were supposed to straighten out. Things were supposed to be getting better. Things were going to be more straightforward. A lot of people had hope that he might even drop the case. And to those of you that think that, I think I said a long time ago, that's not going to happen. And
I got it on in the first place.
Yeah, I've had some discussions with different people about why he took it on in the first place. And it's just, fast forward 10 years from now, Americans have a very short memory. People don't even remember what happened on New Year's Eve over in New Orleans. And that was big. In the scope of things, 10 years from now, people will say, oh, yeah, Brennan, I know that name. Oh, yeah, Brennan, I know that name. But why he had to do it on this case, I don't think a lot of us know. I don't think a lot of people understand. So I don't know, Laney Law. Should we go on to the other two motions that we have, or should we cut it in half and do another episode? Or should we do our viewer comments? I have viewer comments.
So while I am excited to see what our commenters have to say, I have something that the commenters are going to be even more excited to see. On our next episode, we have the pleasure of being joined by, you guys may know their channel, The Glarer.
Hey, Glarer, how are you?
Hello.
How's it going?
Yeah, so thank you so much for joining us. And in our next episode, we're going to be discussing what Proctor had said in those texts.
Whether you are in the grocery store, the gas station, or anywhere else, please remember to be kind to people. You don't know what they're going through. And the same goes for our comments section. We want you to comment, but be nice, be kind, be positive if you can. And thank you for watching. Be sure to like and subscribe. Have a good one.